As that sense, in my career as a criminal lawyer, as a public defender, then I worked in international criminal law. I was part of the groups of NGOs that participated in the creation of the International Criminal Court. My focus was really on the defense, on making sure that there was going to be a strong defense at the International Criminal Court. And I was very involved in the creation of the International Criminal Bar for the International Criminal Court, which in the end didn't succeed because the court wanted to keep everything inside. They wanted to make sure that they didn't have external powers. So we could talk about that for a long time, but it certainly taught me a lot about the balance of the three pillars. And we have three pillars in the UNGPs, and we had three pillars at the court. I mean, the court, the prosecution, and the defense. And so I feel I spent my life on third pillars. And human rights was a very interesting field of practice until the US election, which basically has changed a lot. But I still want to take you through the travel of what is business and human rights, because if not, I could just stop right now and talk to you about the US, but I don't think that's very interesting. What struck me, especially coming from the NGO world at the UN and having practiced criminal law for a long time, was the multiplication of norms, the expansion of international law at a very, very fast speed. It was like a patchwork, and we needed to make sense of that patchwork. And I was trying to tell my colleagues in that space that human rights was something they had to take into account. And they were saying, no, it's soft law. We don't care about soft law. We're not bound by soft law. So I thought to myself, I need to find a way to tell them this is not just soft law, it is applicable law. So I conceived of that galaxy of norms. I think you can put the slide of the galaxy on the, not that, I think it's the last one. Yeah, this one. So, I mean, the presentation could have been longer, and I could have done what I do sometimes is just go from 2000 to 2025, but that gives you an idea of everything that goes into what we call the galaxy of norms. So I started working on that in France at the time of the adoption of the devoir de vigilance in 2017. And then I went back to Washington, where I was collaborating with a professor at Georgetown, Professor Mitt Reagan. And I told them, Mitt, we've got to do something to explain that law to an Anglo-American culture of law, which is very different from the civil law. And so we came up, I mean, it took us a long time. We came up with that article that I believe, Isabella, has referenced to you, but if not, I'll be happy to send to you. And I don't think it's outdated. I think it's still relevant. It's the politics that has changed, and I'll explain to you how I see that. So our idea was to show the evolution of norms and how these norms were traveling through what we identified as 5 rings to make soft law become hard law, and the co-construction of hard law and soft law together. So we identified the core as being hard law, the red, everything that's in red, and proposed legislation is also the red, but that's the core. That's the hard law that you have to enforce, you have to apply. It's mostly criminal law, but it's also everything to do with tort law and civil liability. And then the second ring is the ring of reporting. So this is the ring of what we call, the first law, we call it legal responsibilities of outcome and duties, prohibitions. But the second is legal responsibility to report, which used to be marketing, but now it's been codified. So it's an obligation. People don't take it very seriously. They report whatever they want, but still, I mean, it is some kind of hard law. And you can debate that once you have that obligation, you cannot report fraudulent facts. You have to report facts. You can report a limited number of facts, but you still have to report facts. And so we call that legal responsibility to report. And then the third one is the legal responsibility for process. It's about the behavior of corporate actors. And that was very developed by the OECD. And they called it responsible business conduct. And they went from 2011 to 2023 in developing these principles and telling companies how they have to behave. But it's kind of become a norm of behavior, which is assimilated to the duty of care, but it's not really the duty of care in common law. It's a duty of care in international law. And that ring is being formed by the inclusion of hard law and soft law. Soft law being the fifth ring, everything in blue, and the fourth ring, which is everything to do with contracts, codes of conduct, and standards being developed by industries. So the fourth and fifth ring are transiting back into hard law via that third ring of the legal responsibility of process. So the idea is that it's being co-constructed, and we see it a lot in court cases, that has recognized the value of the UNGP as something that has to be taken into account when it was endorsed by a community or by a country. And so the idea is to see that we propose that this is the hardening of soft law. And of course, it is soft law. And when we come to the US, we'll explain how this has been moving. But then I studied a lot the different legislation that were adopted, whether it was the French Devoir de Vigilance, the UK Modern Slavery Act, the European Directive, the CS3D, the CS-DDD, the European law on deforestation, not law, should call it directive, and then the new directive on the interdiction of forced labor and child labor products entering into the EU space. That one has not been enforced yet. It's adopted, but it's not quite there. And the UK Modern Slavery Act, that's interesting. It was before the French law, but it was really a reporting law, except it didn't do much. So they amended it in 2019. They have more incitement to do more things now. And you have the law on supply chain in Germany, which is very, very detailed compared to the French law. And in Norway, in the Netherlands, they were going to adopt a law on child labor in 2022. It finally has been put on hold because of the reduced. That was prior to the election. So the law has the U.S. California Transparency Act, which is the first law of transparency before the UK law, and it was on modern slavery and labor. And it was under the responsibility of the Attorney General of California. There's been several judgments. It's been an interesting law that has lots of little sisters and brothers in the US and different states on different forms, but not as compelling as that one. And in 2015, under the impetus of President Obama, they amended the tariff. Everybody knows the word tariff now, but they amended the Tariff Act of 1930 to make sure that The Custom and Border Patrol had the power to stop goods at the border. They could impound products being produced by child labor or slave labor. They even adopted also a specific law on products from the Uyghur region in China, to forbid all these products were tagged with a presumption of forced labor, and they could not come in unless the importers could demonstrate they were not the product of forced labor. All that was happening, and Obama, at the end of his presidency, adopted a national action plan to make sure that the UNGP would become part of the legal landscape, and it was amended by Biden in 2024, and it was part of the U.S. State Department. They had committees in place. They were going to do a lot of things. Everything has been put on pause. And Canada also adopted a law against forced labor and child labor and supply chain. Australia has a Modern Slavery Act. New Zealand was planning to have a Modern Slavery Act. There's a law in Sierra Leone. There's one coming up in Thailand. So it's just to show there was a multiplicity of laws developing everywhere, all mandating in one form or another due diligence. We can talk about due diligence at some point. And of course, these laws, whether it's Germany or France, had a component on environmental obligations. For corporations, they had to respect human rights and the environment and adopt it in their due diligence plan. So you have the famous case of Shell in The Hague in May 2021, where basically they forced Shell to reduce its emission of 45% by 2030. And they concluded that Shell was responsible for its own CO2 emission and those of its suppliers. Shell then went to the UK. They closed their head office in the Netherlands. They went to the UK, and then they were expected by the environmental groups who said, you're not going to escape like that. We're waiting for you. We're going to go after you in our own. They went to appeal. They kind of won the appeal at the same time as it's a very complicated decision. It's at the level of the Court of Appeal. It's probably going to go to the Supreme Court. But still, the judgment recognized an unwritten duty of care on Shell to respect human rights and to respect the people that had endorsed the UNGP. So I think this is a very, very interesting decision, and a decision that's still going to be part of our legal landscape for a while. It is a decision that based itself on the European Convention on Human Rights, and also the ICCPR, the International Covenant on Civil and Political Rights. So they really were broad-minded in looking at these issues, and they focused in what I call the new legal reality, the people. I mean, it's not just about the black letter of the law. It makes sense of the black letter of the law in the context that's evolving so quickly, social and political context. You cannot just do these decisions now in looking strictly at the black letter of the law, because they will not fly. They will be denounced by civil society and by the people, and in my opinion, rightly so. Law, if it's to be relevant to our societies, to the rule of law, has to adapt. That could be the discussion of a long, long seminar, but I mean, it's just something that I've observed as a practitioner, and that's something that I think needs to happen in many, many ways. Many other cases that happen in that landscape. One that's interesting, very, very different from the Shell case, is the Rio Tinto case. So there you have Rio Tinto, that huge, massive mining company operating in Australia and digging for iron ore for China, big need of iron ore. So you had two divisions in Rio Tinto. You had what I call the soft power and what I call the hard power. And the soft power were the anthropologists, were the civil society organizations working together to make sure that the veins of iron ore that were to be exploited were not contrary to the rights of indigenous people. And the the laws, the mining laws of Australia were such that once you had signed a contract, you couldn't change it. It was done. It was, even if you had new facts, you were bound by the contracts that you had signed. So there was a vein of iron ore that was very rich and that went through a cave. And by exploiting that vein of iron ore, they ended up destroying caves that had been inhabited by Aborigines and indigenous people for 46,000 years. They thought, who cares? There was a big division, as I said, between the soft power, the people, the anthropologists working to advise, and the CEO and his little gang and the board, and they said, well, we have the hard law on our side. It doesn't matter that we did what we did. The law doesn't force us to change the contracts. So the direction of Rio Tinto said, fine, we'll change the, we'll cancel the bonus that you were supposed to receive. So they won't get a bonus this year. And the shareholders said, no, that's not good. We want much more than that. We want these people to be punished. So they ended up having to resign. I'm not sure with or without bonuses, but Rio Tinto was ordered to reconstruct the cave and to put them in the way they were, which I don't think is really possible, but it ended up amending the mining laws to make sure that this never happens again. But the resigning of all these executives from Rio Tinto was like a shockwave in the mining industry. They realized, well, we cannot really do what we want anymore. We have to take these social, environmental issues into account, which is really not the mindset they're trained and forced to act upon. So it's a very different decision from Shell, but it's to show you there's so many decisions that are happening in that space, more and more. And in France, there are many decisions that happen. I mean, there's the Total Energy to do with the devoir de vigilance, and they requested a new compliant report within 3 months. It's still pending before the courts, but what's interesting in France is they've created a special court at the level, the Court of Appeal has created under the economic pole, a court in business and human rights, where judges are being trained specifically in that space. So I'm sure it's going to give way to a lot of interesting decisions. There's one about EDF, the electricity company operating in Mexico, where they have had to move indigenous people, and it's still under the devoir de vigilance, and it is pending. But I mean, I think it's going to lead to a very interesting decision too. And then you have one in Chile about Suez, where the vigilance report shows that several associations ordered the CEO of the Suez Group to publish a new plan incorporating a map of the group's company risk in Chile and remediation measures. And we'll come back to the issue of remediation. So the rulings handed down on June 18, 2024. And basically, for the first time, the new chamber, the Chamber on Business and Human Rights, created to address the emergence of these disputes related to the duty of care and environmental responsibility, rendered these decisions. And they decided that first, there's an issue on stakeholder engagement that's kind of very important. It's been debated, and again, I'll come back to that specificity of stakeholder engagement. They decided that there has to be a proof of the effectiveness of the plan, not just the fact that the plan was drafted or written, but it has to be effective. And the mapping has to be specific to the specific risk factors. And the plan must allow for measurements of whether the assessment strategy is consistent with the severity of the breaches. They have to alert and report mechanism in consultation with representative from trade organization, and they have to take appropriate action to mitigate or prevent serious breaches. And if reasonable, measures must be sufficiently precise to have the expected effectiveness in order to prevent the most attacks from occurring and limiting the impact of other risks. So this is very, very quickly brushed the scene of business and human rights as we had it prior to the US election, because I want to spend the second part of my talk talking about access to remedy, which to me is very important. I'm going to quickly move on to talking about what's happening in the US and how it's impacting these laws. As I said, there was a new action plan in place at the State Department that was going to take a lot of measures to really work with Europe and to implement due diligence and remedy and have a discussion, a transversal discussion with enterprise and the legal community. Under the new administration, in the last 2 months, we have seen the independence of the judiciary. I know that you Polish people are very familiar with what happened when the independence of the judiciary is jeopardized. And we can say it's very severely jeopardized in the US right now. You still have very courageous judges rendering decisions to try to stop some of these actions. Depending on whether you're in a red state or a blue state, they're very different. And then you have the Supreme Court, of which I'm extremely suspicious. And so far, they've given him a lot of leeway. And people, I don't think, really measure, unless they've lived it like you have, how much the judiciary is the cornerstone of the rule of law and democracy. And in the US right now, it is being jeopardized in a very severe way. But what is worse and adding to that is that we have an attorney general that's totally sold to the president. She's like the lawyer, the private lawyer of the president, and she does whatever he wants. And she's politicized the service of the prosecutions in a way that they were not so much done before. And law firms, big, major corporate law firms are caving in one after the other to the demands of the president, saying, we are not letting you use words like DEI in your different text or in the different cases you're taking. So anything that's to do with diversity, inclusion, and equity is to be barred. And words like woman and like race are to be eliminated from the work you do. So this is like very, very severe. And they're doing the same thing with universities. And you see the same thing in universities caving in one after the other. And when you tell your colleagues in that country, why don't you unite? Why don't you fight it together? That's the only way to go, is to say, we're not going to negotiate individually with you. We're going to negotiate as a group. And then they would have a chance to stand on their feet, but that's not the way they're doing it right now. And if you add that to the fact that ESG framework, environmental, social, governance framework are being banned, that's not something that you can advise your clients when you work in finance anymore. You cannot use these words. These words are banned, which is something that anyone that studied history knows what it means. It changes the way people think. It changes the way people act. It is a very, very damning climate. And to add to that, climate is also banned. You can't talk about climate. You can't talk about climate change. And to add to that, I mean, they have a list of actions against science, whether it's climate science, whether it's even medicine, like cancer research is being defunded. We don't even know why. It doesn't make sense. But I mean, it's being defunded, and that goes together with huge cuts in the education system, the health and welfare of people, including veterans' care. And so this is, I think, a very bad judgment, because they count on the military to support them. And I think that will jeopardize the support of the military if ever it was there. I don't think it was so much there as they think. And you have the long war on the transgender people. They've become the enemy number one. They represent 0.1% of the population, but they have become the symbol of that administration to bar, to exclude diverse people. So they have to be excluded completely. So if you adapt that to, to the independence of the judiciary, as I said, the selection and appointment process is very politically tainted. The constant vigilance of these groups over these decisions, especially using AI and Elon Musk and his little teams, that kind of makes it very dangerous for some judges. When they render a decision that's contrary to what the president wants, they are being immediately threatened on social media, threatened with death, threatened with being kidnapped, threatened with being canceled, impeached, whatever you want. So far, it's remained in the realm of threats, but these judges, they don't have private security guard. It's a very scary and intimidating atmosphere. And then you come to the lawyers, and it's very extraordinary to see that there again, the legal profession is divided between the blue states and the red states. The American Bar Association has issued very strong position in favor of the rule of law. And all the specialized bar in the US, there are lots of specialized bars like the black bar, the women's bar, the environmental bar, the immigration bar. All these bars are supporting the rule of law. But then when you move to red states, they've been muted. They're totally silent, except in the state of Missouri, because the president of the American Bar comes from Missouri, and Kansas. Nobody knows why Kansas, but Kansas is standing up on its own in a sea of red states. And when we say red states, people don't even realize that these states are so uninhabited. You're talking about a state of 1 million people for the Kansas or the Dakota, North and South, and Wyoming, Montana. These are all red states, but they're very, very poor. Unpopulated, with a very low population rate. 2 days ago, I read that California was going to refuse to go by these rules, and they were going to have their own set of rules. California represents about 30% of the U.S. GDP. They're a force in itself. So they can use that to counter this movement, but the strength they had was they act so fast, so quickly, and it destabilized everyone. Nobody knew what it was going, whether it's the press, whether it's the universities, whether it's the civil society organizations that are being defunded, by the way, very, very fast. So this has an effect. The U.S. Embassy of several countries has written ministries of justice and corporations in Europe saying, don't apply the CS3B extraterritorially because we're going to stop doing business with you. That was before the tariffs. So it's kind of compounding with the tariffs effect. And again, if European countries start negotiating one by one with that administration, they're giving in instead of just forming a united front against this kind of threat and this kind of intimidation. So I can propose maybe to pause here for a minute so that you can ask me questions about that, or I'm going to continue to remedy and remediation, whichever is your preference. Because I want to show you why I believe that we can still make progress in that space of the third pillar and remediation, because it's not fixed by laws, it's more like by action. So, and that's been really the weak pillar of the UNGPs, the weak pillar of that construction, where we have put in place tons of process, but basically the people at upstream, the people upstream, the supply chains are not being impacted by these laws. Their fate is the same. It's not improved their life. in any way whatsoever. So you have two aspects. With tariffs, they're going to eliminate their jobs. But with the UNGPs and all these laws, we were trying to improve their lives. But we were not doing it thoroughly enough. So do you want to ask a few questions here, or you want me to continue to remedy?
If I just could suggest, perhaps we if there are any immediate questions, perhaps we can admit one or two, but otherwise I would suggest we continue, because we don't know whether for the streaming, the questions of the audience will be well heard. So perhaps let us continue, and then at the end try to deal with that. Thank you.
Absolutely. So then we come to, for those who are familiar, I just do a quick reminder. The UNGPs is based on three pillars: the obligation of states to protect human rights, which means to adopt laws that will make sure that fundamental human rights and climate issues like people and planet are protected, and that these laws are implemented, which is fundamental. You can have laws, if you don't implement them, it's not doing much of anything. And then the second pillar, which was recognizing the responsibility of the corporate world to respect human rights, which was really a new thing. Corporations never thought that they had anything to do with that it was the space of the state, and that state had to do their job. And if they did their job, so good. If they didn't, so bad. It was not their problem, basically. And there was a lot of discomfort with the adoption of these laws, and to the fact that they had to realize they had responsibility and they had to exercise them. And people were asking me, do you think it's made a difference to have the loi sur le devoir de vigilance? And I can tell you, yes. Corporations that were very reluctant to do anything in that space started taking their responsibilities more seriously and acting. But again, that was on defining the scope of responsibility, how to do about it, and what to do, and probably the hope to do the least possible. But anyway, the third pillar, which was the access to remedy, was always neglected. It's been true at the UN. We've seen it at the UN Forum for as long as I've been going, since 2012, that it was a space that was not being occupied, developed, or improved. Again, access to remedy in the UNGP is the obligation of both states and corporations to, in practical terms, make sure that they together develop the means and the ways and the implementation and the mechanism to ensure that people are compensated for all the harms they are suffering from either the lackadaisicness of the corporations, or for the lack of action, or for the absence, because traditionally, remediation was very capriciously offered by some corporations when they felt like it, when the pressure was big enough. I'll give you an example on a file on which I worked, the not Rio Tinto, the Barrick Gold in Papua New Guinea. There were allegations of systematic rape on women around the mines, and they decided, because the publicity was so strong around these allegations, that they decided they had to do something. So they set up a system to compensate the women victim of rape. But they made them sign a waiver that they were renouncing to have any legal recourse in front of the tribunals, which, in my opinion, is completely illegal. You cannot trade with a criminal act. And it went all the way to the UN Council on Human Rights, because it was denounced by everyone. So they came back and they did another process, and it was better. But the issue is that these remediation are always organized, set up, decided, and managed top down. And that's the problem. I mean, they decide what's good for these people. What are the good remedies? What they should be getting. They don't consult. They don't consult them. They don't know what they suffered. They don't know what they want. They think they know best. And to me, that's the wrong approach, the totally wrong approach. So I've been working in that space for a long time. I've been working as a lawyer advising clients on due diligence, but I've also been working in the space of access to remedy. And I started trying to use mediation as a tool in that space. So I'll give you one example, and then I'll present you with one framework. Am I okay with time? Well, you have to tell me how long I have left. Okay, so I'll take 5 minutes for each. So I was asked during the pandemic to do a mediation in Myanmar, but it was virtual because it was the pandemic, so it was done by Zoom, but it was still an incredible experience. I was asked to mediate a conflict between Burmese workers and Chinese employers that had shut factories at the time of the coup, and that just didn't feel they had to pay them anything, that they just could close the factory, and that the government, as they told me, would take care of the workers. And I kept telling them, which government? They said, well, the government. I said, no, it's a junta. They're not going to take care of the people. Anyway, I did what we called a multi-party conflict, multi-party mediation in a conflict zone. And I was to mediate the conflict between 800 workers and Chinese employers with the brands, the European brands, and the international labor being part as witnesses to that mediation. And it was in Chinese, in English, in French, in German, in Burmese. I mean, we used a lot of translators. It went on for 6 months. And I mean, there were two main issues: compensation for these Burmese workers who were being persecuted every day because they were members of unions, and the reopening of the factory in that context. And after 6 months, we were able to get to an agreement, which we were 10 mediators doing that at the same time. And I was one of two that succeeded. And the reason I believe I succeeded is that I used the leverage I had in a way that the others didn't. I was working with the unions and with the brands to see how far do you think we can go? What do you think we can get? And also another factor that becomes clear to me, the Chinese employers were so angry to be caught in that process that they would open every session by screaming their head off at me. They were so angry. They were very unpleasant. And first time I thought, well, what am I going to do? Am I going to just say goodbye, it's finished, we're closing here? Because if I had said that, that was the end of the mediation. So I thought their anger is not directed at me. It's directed at all the pressure they feel from their peers, from their government, from other competitors, from the workers, from other people in Burma. They felt like, and from the brands were putting pressure on them to come to a settlement. And I was the person that could get their anger. And I thought, if that's what it takes, I'll take it. I'll almost welcome it. So every time I would be screamed at for 30, 40 minutes, staying very calm, very detached. And at the end, I would say, I see you're very upset today. Do you want to work? And they would say, oh, yes, we absolutely want to work. We want to work with you. We really trust you. So I thought, I'm getting somewhere. And in the end, we were able to settle. So this is, to me, an experience that should be replicated in many, many, many formats and many, many ways. So that's one thing I wanted to share. The other thing is you can put the other images on. Well, this is fine. So I was hired by the European Union in November 2022 to build a dispute board plus. So dispute boards are traditionally used in the construction sector to handle disputes between contracts parties, and it's really focused on the contracts. So I said, I'm very interested, but I will do it only if you let me get the stakeholders, the vulnerable stakeholders, involved in the process, because if not, I'm not interested. So they said, sure, we give you carte blanche and you can do it. So the idea is we set up this process from the time the contract is signed, and we do a meeting where we map the stakeholders, we exchange information, and we keep having meetings to the point where we get to a stakeholder engagement plan, which you see under the fourth green square. And then the committee that's being formed, the conflict management committee, the CMC, is there to manage the engagement throughout the project and to make sure that everybody will respect their engagement. Everybody is engaged into the stakeholder engagement plan. The stakeholders and the contractual parties to the project, the local governments, everybody involved. And we are there to make sure that it's properly handled and to do informal settlement of issues in the first instance. If it doesn't work, we go to formal procedure where we receive, basically litigation reports, complaints, and again, we try to handle it. And if it doesn't work, we produce a report and recommend mediation. We don't even talk about arbitration or litigation because they exist anyway. We don't feel we're there to do the promotion of arbitration. We are working right now to get this process into the guidance of the new UNCITRAL treaty, the Treaty on Bilateral Investment Treaties, as a preventive tool, because the bilateral investment treaties have been, in my opinion, a disaster for the poor, small countries that are being imposed conditions by big, rich country. And when there's an arbitration, they usually lose, because if they broke the contract for whatever legitimate reason, it doesn't matter. They broke the contract, so they have to pay huge amounts of money. It paralyzes the project for years, and it doesn't settle anything. So we think, and we presented that to the World Bank. We presented it to several development banks and development agencies, and we're looking for the pilot project to implement it. We haven't found it yet, but we're very confident we will. And probably the best way in will be when there is already an ongoing conflict and we're asked to mediate the conflict, and then we can set up the process for the second phase of the project. So happy to answer any questions you might have. That was very rushed. I hope I was able to convey enough information in such a rushed presentation.
Elise, thank you so much. You are extremely disciplined. I suggest that we perhaps move now to the interventions, and then there will be a full Q&A at the end. Probably that will facilitate the organization. So as first, I'll ask Professor Kędzia to take the floor and share with us his reflections. Thank you.
Thank you very much. I'm really impressed by your lecture. At least this was really not only very informative, but I think it was in particular encouraging, because you are talking about difficult times, but you are also, in fact, showing the way out. And all these processes you described are really very impressive. And thank you very much for this sort of attitude and this sort of lecture. Well, I would like to focus on these turbulent times a little bit. And I remember from my school days doing pretty well with equations with one unknown, worse with two, and then, well, I will put it aside. Looking at Trump's policies today, the number of unknowns seems much higher, and even one can feel that the equation itself disappears. So I'm embarrassed and not being alone in this mood does not help too much. We are dealing with a fuzzy picture that currently doesn't allow for the pixel by pixel approach needed for more detailed analysis. Even the general prediction that all the distortion will eventually end seems trivial in this context. I'm not an economist, but I would like to quote Professor Douglas Irwin from Dartmouth University, who wrote in The Economist that Donald Trump is a 20th century man presiding over 21st century economy, who wants to take it back to the 19th century. So this is, I'm not sure that this diagnosis is fully correct. Perhaps it should be fine-tuned in one or another way, but I'm not sure that it is exactly what I want to say. So squaring the circle, yes, but it is not good enough to say we need to enter this territory. And this is exactly at this juncture that I would like to congratulate you, Elise, on choosing the topic of your today's lecture. Much has been said about the space for populistic arguments in the US, elsewhere, also in Poland. But even if we say that populism as such is a mistake, moreover, one of those mistakes which accompany people throughout the history, we should probably also realize that if the forces of progress will not try to seriously diagnose and address the sources of populism, I mean, its underlying fears, hopes, wishes, and dreams of people who feel to be left behind in one or another way. The advocates of democracy might unwillingly themselves contribute to this impact of populism on our life. From this perspective, we can also look at the results of the last US elections. They may corroborate the curious statement by notoriously quoted Vice President Dan Quayle, who, according to Wall Street Journal, said, "I believe we are on an irreversible trend toward more freedom and democracy, but that could change." Striking enough, this contradiction, irreversibility, and change does not occur today to be entirely absurd. There are many possible approaches to Trump's attempts to reshuffle the world. But let's look at two of them. One is the so-called and often quoted Chinese perspective of crisis. As we know, crisis in Chinese is perceived as danger and a point of change. Many speakers translated supposedly wrongly as danger and opportunity. If we agree that Trump's challenge is pushing the world into a crisis, then we also agree that it is dangerous, even if only temporarily. Still, the outcome depends on how we manage it and use the newly emerging opportunities, such as, for example, growing European solidarity proposed by Trump.
one example.
Activities in the framework of humanistic values protected by human rights. However, in favor of business social responsibility should, and this is a very important requirement, build on social actors. On social actors, the experience and strength as agents of change, and a balancing factor against government. It is crucial to recognize that, as in the past, the windows of opportunity will again open for further steps to establish effective corporate social responsibility and accountability. However, as you know, such openings tend to be short-lived. Downturns in international politics should be used to prepare ideas, concepts, and proposals to be put on the table in the right time. Otherwise, these windows of opportunity can easily be wasted. Thank you very much.
Thank you, Professor Kędzia, for the insightful intervention. And I suggest we immediately move to the second intervention by Advocate Mikołaj Pietrzak. The floor is yours.
Thank you very much. I am absolutely honored to be here. It's an incredible privilege. I'd like to thank Dr. Schiefauer, Dean Cusack, and the entire Faculty of Law for the invitation. I'm very grateful to follow Elise. It's a hard act to follow. And now, after following Professor Kędzia, it's an even a harder act to follow. I feel I have very little to offer here in this temple of academic excellence. I am not an academic, as is painfully obvious, and will become even more obvious as I go on. What I can offer is some insight as a practitioner in the lowest and perhaps highest level courts before international bodies, and also as a practitioner, a member of supervisory boards in smaller and larger companies. And here's my first insight. Elise mentions these terrible violations of human rights, very physical, very palpable, the way she describes it: rape, forced labor, practically slavery, in places very far away, in distant countries which we identify as, hardly identify with the rule of law and democracy. But make no mistake, these large international corporations, these large businesses, both larger and smaller, are very involved in your rights and freedoms, here and now. Every one of you has a telephone. Every one of you uses social networking applications, messengers, all kinds of apps to communicate. when I take on a criminal case and I open up the files, it's no longer fingerprints, it's no longer testimony. 90% of evidence comes from your telephone. And that is, of course, download from your social networking sites, from your computers, it's computer data. It's information, data and metadata regarding your private lives, which comes from private-owned businesses, which operate telecommunication services. Now, how does that translate to rights and freedoms? That's your right to privacy, Article 8 of the European Convention on Human Rights. That is your freedom of speech, potentially, if social networking sites are deciding what should be published and what should not, Article 10 of the European Convention of Human Rights. That is your information autonomy as described in our Constitution. What happens with information concerning you when it's in public circulation? And we can, on another date, we could go on to the issues of proportionality of that invasion into your rights, whether it's legal, whether it's proportional, whether it's necessary. But the fact is, your rights are affected today, here and now, by these large international corporations which have sway on all of our lives. About 15 or 20 years ago, I started hearing this idea of horizontal application of human rights, that human rights isn't just about the traditional relationship between an individual, perhaps a company, and the powers that be, which is the state. The state governs our rights and freedoms, is responsible for our rights and freedoms, and it affects us in this vertical relationship. And we started hearing, no, there's a horizontal relationship between private entities, individuals, us, and businesses, which from the point of view of the state are private entities. That first appeared around the term social corporate responsibility. We all started hearing SCR, it started to become very fashionable. Then, thanks to the United Nations Global Compact, we started learning what is this whole idea of sustainable development. And now we hear ESG. But ultimately, from my point of view, the ultimate premise is businesses should generally not violate our rights and freedom. That's what we're getting at. That is the bottom line. But there's a very dangerous reasoning behind that. And that reasoning is, it is the responsibility of businesses not to violate rights and freedoms. And the reason that we would all agree with that on a moral and ethical level. And we would all like to be safe from businesses abusing our rights and freedoms. But structurally, in terms of how the relationships, legal relationships are built, I have never supported that directly, that line of thinking. I strongly believe that the state has a responsibility to shape the law, including laws that bind us as citizens, but also companies. That companies need to abide by certain standards of respect for rights and freedoms. We see that most prominently on a day-to-day basis in our labor codes. Companies cannot effectively enslave us. Why? Because the law created by the state obliges them to respect these human rights standards. Now, we see over the past years, Trump is just the last example, but certainly we know these examples very well. They're very close to heart. We see Orbán in Hungary, Prawo i Sprawiedliwość in Poland over 8 years. We've seen illiberal governments eroding the sphere of rights and freedoms and mechanisms intended to protect rights and freedoms and create a stronger government at the expense of our rights and freedoms. We see a movement towards illiberal forms of politics, illiberal forms of government. That is one threat. But alongside this, we observe another phenomenon. That is the increase in power of international corporations, increasing to such a degree that they no longer are subject to states and state laws, but the balance has shifted. So now these international corporations have extreme control not only over us as individuals, but over state. And you can see that perhaps most brutally with the example of Elon Musk and the recent elections, these international corporations have amassed such power, not only financial power, but power over our minds, power over our day-to-day behavior through the applications we use, through guiding us with our finances, that they sway influence. Their influence is far greater than that of the state. Now, when we say corporations, what do we mean? We mean, in effect, the handful of people across the world, multi-billionaires, who control the corporations. So these handful of people, through these vehicles, such as X, such as Facebook, such as Amazon, such as, well, the list goes on, but it is ultimately a handful of people, have never been elected, but they have incredible influence over our day-to-day lives, and what I'm trying to get at here, most importantly, now they have influence over government. So the old paradigm whereby the state controls corporations through law, ordering corporations to abide by human rights standards, social corporate responsibility standards, is no longer applicable. If it's the corporations that sway influence over the state and not the other way around, we get to a situation where we have our laws, our human rights standards, established not by democratically elected officials, by people with no democratic mandate. That is perhaps most visible because it's very manifest, it's very ostentatious in the case of Elon Musk, but it's visible throughout Europe, in Poland. So I think we have ahead of us, as human rights lawyers, a very difficult task, as citizens perhaps more importantly than human rights lawyers, reorganizing this power structure so as to return to a situation where the ultimate responsibility for creating laws comes from a democratic mandate rather than from from power coming through development of business. I am a very big fan of the free market. I was born in communist times, as you can tell by the gray hair. And I remember that incredible moment of freedom in 1990. That moment, I was a teenager, but I knew then that a miracle had happened. And as a young student of law, the fact that at second year I was able to go to a law office in Poland and work, it felt, in Polish there's a saying, I caught God by the legs. That doesn't translate very well. The point is, it was absolutely miraculous. And we were thrilled. I'm a big fan of the free market economy. But that being said, if the free market economy led us down a road where we have now no longer a broad array of companies competing and not constituting a threat to our rights, but rather we have a very narrow handful of multi-billionaires who control a broad spectrum of our day-to-day activity effectively, and as a result control the state rather than the state controlling or exert very significant influence on the state rather than the other way around, then we've come to a situation where the free market has led to a warped effect. The free market is no longer free, it's led to an abusive situation. Now, that happened in history. We remember what happened at the end of the 19th century when the railroad tycoons in the United States gathered too much power. They had a monopoly. They had monopolies which led them to abuse the free market. That resulted in the Clayton Act, the Sherman Act, the Federal Trade Commission. So antitrust legislation being put forward over a period of about 20 years to diminish the influence of these monopolies, to split them up, to protect the principles of free trade, the principles of a market economy. I would suggest to you that we, and perhaps not we, but your generation, I look at the younger people in this room, That's a very low threshold. Most of you are younger. Because it's going to be your job, ultimately, to split up these incredible corporations, to weaken them, not only in the name of saving the free market in democratic capitalist states, but in now also to save human rights standards, to save the very democratic process itself. Because right now that is the democratic value which is most at stake, not the free market. That's secondary. I would say not even human rights, because they can't exist without a democratic process. The democratic process is now under threat by these incredibly powerful transnational corporations. And I think the only solution we're looking at in the future is an international effort by many states acting together to decrease the power or divide the power of these incredibly influential, not so much companies, but individuals who stand behind the companies. Have I made it on time? I think. Thank you.
Thank you so much. We had 3 wonderful interventions, very inspiring, very rich. Now I think it's high time to give the floor to your questions, to your perhaps comments. So the floor is to the public. Are there any questions?
Maybe first one technical question. We in Poland and Europe don't really have DEI. So what it is? Because I hear a lot about it, but I only hear about it from people who are against it or for it, and they don't show full picture. So I would like you to just explain it, what it really is. DEI. Yes, DEI.
That were put in place to fight racism, to fight misogyny, to fight exclusion, to ensure better share of wealth, and to encourage, like, for example, corporate board to have more women, more people of color, same thing in universities. So it was a progressive view. It led some excess that people call wokeism, where, I mean, it became like a religion. And I mean, to me, that's something that could have been fixed easily, but it became the weapon of the extreme right, both in Europe and in the US, to defy anything to do with equality of any kind, any fight against racism. I'll give you an example. 2 days ago, they removed from a website, I don't know which one, the history of a tunnel that was built between Detroit in the US and Canada, where a woman helped slaves escape to Canada to freedom. And her name was Tobin, I think. I can't remember her name right now, but Harriet Tobin, that's it, Harriet Tobin. And when you go to Detroit, you have big signs in favor of her, to command what she's done. They wanted to remove any mention of that, like it didn't exist, that railway was like an invention of some kind. And there were so many protests, basically in 24 hours, that they put it back on. So that was the spirit. The spirit was to encourage diversity. The US is the most diverse country on earth, in my opinion. So it's kind of too little, too late. They've lost the race. They want to be back in the 19th century to a white Christian male nation. This is not going to happen, but that's what's prompting them to fight against diversity and equality, which is a bad word for them. I mean, and I'll just give you one anecdote. Kofi Annan, before doing all the work that he did in the space of business and human rights, said in the mid-90s, when commenting on globalization, if we don't bring about more equality and more wealth sharing, we will end up in a world where all the extremism are going to be prime. It's going to lead to extreme racism, extreme Islamism, extreme misogyny, extreme inequality, extreme racism, everything you want extreme. And he had predicted that in the mid-90s, and we're seeing it now.
We do have DEI politics. We do have DEI instruments in place in Polish law and in Polish commercial politics. Keep in mind that for 8 years we had a government which was analogous to what you're seeing right now in the United States. So it was, to put things nicely, very conservative, but quite against equal treatment or anti-discriminatory mechanisms. So we had 8 years where that was contested, perhaps not as manifestly as in the United States right now, but it was contested. But right now what you're seeing is, now, just to be clear, I'm not a great fan of this government, but it's certainly more within what we would call a democratic constitutional norm than was the previous one. And now you're observing this government, for example, issuing zalecenia, guidance to state enterprises, guidance regarding the participation of women in higher management. Because of course, in Poland, if you look at most state companies, you'll see 50-50% men and women on a lower level, but the higher you go, the fewer women there are. And it is a banal thing to say that's not because women aren't better managers, but something happens along the way. It's the culture, it's the biases that ends up with women being less represented at a higher level. And so part of what you see today is the Ministry of State Assets is issuing guidance to state-owned enterprises as a shareholder to ensure equal representation of women in management and supervisory board bodies. That's an example. But I think when you think of DEI in our Polish and our European context, the most important instruments are at our disposal. Applications to the European Court of Human Rights. Most changes over the past 30 years in Poland in terms of equal treatment, anti-discriminatory changes, come from individual litigation where somebody was fed up with being treated like they were worse, fed up with not getting a job because they were Romanian or Roma in origin, fed up with not getting advanced because they were women, fed up with not being able to publish because they were LGBT, and they litigated. And that's where you see most of the change happening over the years. So that idea of inclusivity and anti-discrimination and diversification is very present in our legal culture, but it perhaps doesn't take the same shapes as it did in the United States before Trump. And that idea is also under threat when you get a conservative government, or rather a populist government, because I don't think conservatism is a threat. I think populism and authoritarianism is a threat, because a key component of authoritarianism is finding a foe and redirecting blame. We saw that throughout 20th century history, most notably with Nazi Germany and the Jews. But DEI goes against that kind of hate targeting.
Are there any other questions? There is a question over there.
That governments could use to regulate and stop the international giant corporations.
Well, it is a very, very interesting and important question, but I'm afraid there is no simple answer to it. Because, you know, I have a little bit of the feeling that all the arrangements within the international organizations are good, or perhaps have been developed for, let's call it, time of business as usual. And we are not in such a time. So your question is really very, very pertinent. And we need to find the way how to prevent abandoning the protection of human rights in this particular situation, in this period. Whether this period is really to such an extent extraordinary that we need to find some special approaches, or we should rather focus on enhancing what has already been developed. This is a question. I'm you know, the international community is acting always on the principle of unanimity. It means when we are negotiating a treaty, we are negotiating any agreement, in fact, it is based not on voting at the end of the day, but on consensus principle. And this is very difficult to be achieved. What is even more dangerous, that if you are seeking consensus, in fact, you agree that you will build this consensus on the lowest possible common denominator. So this is a tricky story. Therefore, I think we are now in a period, and I was trying to say it before, so I will not further develop it, but we are in a period when we need to be aware of the fact that in short term at least, there will be no room for any new instruments, new arrangements. I think this is a realistic approach, but I would love to be just persuaded that I'm wrong. But no, may I just say that may I just finish that? Therefore, I think we should even try to make an inventory. Elise did it today to a certain extent, an inventory of what we have already available, and try to make our best from what is available. This is, and develop it, and there is room for that. I think we should, at the same time, parallel, work on new devices, on new arrangements, prepare them for the window of opportunity. Because if we start to work on them at the moment when the window opens, then the window will shut, and we will still be in the process of preparations. So I believe we need to go these two ways parallelly. On the one hand, really exploit what we have at hand, and exploit it even more firmly, with more dedication, with more mobilization. At the same time, we need to look forward and try to develop what should be in place in the future. This is just a direct response to what you said. And when you are saying, well, practically what do you have at the moment? You know, we have still, I would say, unexploited device, which is in the case of business, is the due diligence concept. The due diligence, you know probably what is due diligence. This is, you know, that the businesses should show the due diligence with regard to the impact on human rights of the investments and other activities. But, you know, the question is how to persuade business to do it. You can apply some guidelines, as we said. We can try to develop some laws in order to make it an obligation under law. But on the other hand, I think there is a work to be done also on the part of, let's call it, human rights advocates, human rights crowd, as we can call it. Namely, I'm not sure that we, as human rights people, we have been able already to demonstrate to business that business would be better off with its core activities if they apply human rights. This is a weakness on our part. You know, for example, there is a concept of human rights impact assessments, which should be carried out before a business corporation takes a decision on investment. Okay, that's perfect. Sounds perfect. A friend of mine, an Australian, wrote a PhD about a human rights impact assessment. There is also another approach, which is called human rights-based approach. Should be applied also. A Swedish guy, a collaborator of UNICEF, wrote a book about how to apply human rights-based approach. Both these publications are so terribly complicated that, you know, if I would be a businessman, I would just put them on the shelf in order to demonstrate that I am not an enemy of that. But to apply it is terrible. So we have to find a way how to really demonstrate to business, to other partners, that this human rights approach is not only a question of preaching for human rights, but is a question of making use of human rights as a not only comfortable, but also helpful tool, device for doing business. So, okay, when I start, then I will never end. Okay, thank you.
Counter the complexity and the inefficiency, thank you, of human rights impact assessment that were done maybe with a good purpose to start with, but they would go to a region like a mine in Peru, and they would build their report, mostly engineers, very technical. They would then present it to the locals and say, give us your comments. We'll come back in 2 months to consult with you, because there was an obligation of consultation. And these populations didn't have the knowledge, the resources, the language skills to be able to make any sense of an 800-page technical report on human rights impact assessment. It had nothing to do with their lives. So it was built on good intent, but not practical. So far remote from the reality of the people where you wanted to implement your mind. And this is what we designed to make it much more practical, simple, accessible, and feasible, to make sure that you build a partnership with the community before you start digging, and that you develop the project in their interest, not just yours. That's one thing. The other thing I want to say to your question is 2 things. First, we need to get rid of money in politics. There's been an awful decision in the U.S. called Citizens United, where the Supreme Court decided in its incredible wisdom that corporations were citizens and they had the right to spend as much money as they wanted in politics. So you have the disaster today of money in politics. I mean, Elon Musk has put hundreds of millions of dollars behind Trump, and he's continuing. And so that's one thing where all together as human beings, we have to fight against money in politics. And second thing is young people should vote in a proportion of 95%, because then you would own the system and you could fashion it to your own will. They're not voting. They're disenfranchised. Huh? What
I'm just saying, yeah, but they're voting for the Confederation, so they're the right-wing.
The young people, not the majority, because they're not voting in the large number. Well, protest is very important too. I mean, it started in the U.S. last Saturday. There were 1,500 protests all over the country in the 50 states.
May I?
Go, please.
Before I comment on your very astute question, one comment with regard to what Professor Kędzi said. Professor Kędzi said we need to make corporations believe it's in their interest. We need to convince them. I'm going to put my hat on now as a member of a supervisory board of a very large firm. No company will ever do anything to respect human rights or fulfill other sustainable development goals unless, one, they're forced to do it by law, or two, if they don't do it, their profits will fall. Those are the only two things that motivate a company. They're not going to do it because it's ethical. In fact, I've had conversations with managers who will say, look, I want to do the right thing, but that will slightly decrease profit. I will go to jail for acting to the detriment of a company. Artykuł 296 kodeksu karnego. So I need, my only directive is profitability of the shareholders in the company and being within the law because they want to respect the law. And if the law forces them, they're very happy often to comply with human rights standards. But they will never do it because it's the right thing, because that's how the whole system of corporate participation in commerce is built. That's not going to change. So we, once again, can't rely on the corporations. I strongly believe in the vertical paradigm of human rights, where the state forces certain standards on us and the companies. Now, getting back to your question, before you ask what can we do, what can states do, I think you should ask what can we do. Forgive me. And it's not only citizens, but specifically as a group of lawyers, young lawyers, practicing lawyers, academics. Three things. Advocate. We are, as lawyers, in a unique position to lobby, to pursue political goals, to convince political stakeholders why changes and what kind of changes have to happen. And we can shape these changes like no other profession. Lawyers, not by chance, are disproportionately proportionally represented in parliaments throughout the world. There's a reason for that. This is our profession. This is what you know how to do. So advocacy, when I say advocacy, I mean public advocacy, lobbying in the best sense of the word. That's one thing. Advocate, educate. The sin of omission committed by the legal community in Poland, which led to the rise of populism, was the failure to participate in the educational process for over 30 years, since 1990. If Polish advocates, Polish judges, Polish legal advisors, Polish prosecutors had participated on a daily basis in increasing not only the knowledge of students of law, but of citizens as a whole, young, old, medical doctors, engineers, people who don't deal in human rights on a daily basis, I think that would have been a bit of a civic vaccine against a populist virus. We started doing that too late. So what we can do is educate. And that is certainly the role of everyone in this room. Once again, you have a unique set of skills. Some of you will remember that, I'm sure. That no other group of citizens possesses. Thirdly, and this is perhaps to the practicing lawyers more than others, but also to members of NGOs, litigate. This is something no one else can do. We have the ability to cause changes in the legal system by making judges send preliminary rogatories to the Court of Justice of the European Union, by filing applications to the European Court of Human Rights, litigating before UN bodies to bring about change. That on its own is weak if it doesn't have public support. But once again, if you need public support to enforce a judgment you've achieved in Strasbourg. That's what education and advocacy are. Now, all these three instruments should bring about legal changes which would limit the influence of corporations. This is where it gets tricky. It's not what can be done. I don't think it's complicated. I think it's hard. Because what we're effectively expecting is all Western democracies and all large capitalist markets, including China, we're seeking to have them limit the powers of corporations and perhaps even go so far as to forcibly divide certain corporations, limit the accumulation of wealth in the hands of an individual. That can be done by tax incentives. It can be done in regulatory fashions. Lawyers can think that up. I don't think that's the difficult part. I think the difficult part is creating a political will among hundreds of states at the same time. And that's the challenge. It's possible, but it requires massive resistance and massive advocacy on the part of citizens across the world.
Coming back to this advocacy issue is really a crucial point, but I want to say that I am a little bit more optimistic with regard to this persuasion of the governments and of the companies that it is profitable for business to operate with human rights as a toolbox. And I can tell you that what Mr. Pietrzak said, that in fact for business there is only one way to work, namely to base their work on profit, because each CEO is in fact held accountable whether he or she is bringing profit to the company or not. That's fine. I told you about my meeting with the International Chamber of Commerce. There were 150 high-level managers from all over the world. And you had two groups, the traditional CEOs and the younger ones. And the traditional CEOs were telling the group, the meeting, exactly what Mr. Pietrzak told them. You have to ensure that the companies bring business, and you have to ensure that the company can survive. I remember very well a CEO of Nokia, who was a young guy. Nokia was in troubles. He was a young guy, relatively young guy. And he said, I don't understand this approach. I don't understand this approach because it is outdated. In fact, what we have to take into account is not only the question whether we will put into some facilities additional money. This is not this issue, but we have to take care of our brand. And he referred to the experiences of, for example, Nokia, of Benetton, and so on and so forth. All these brands suffered a lot in economic terms because of the loss of reputation related to exactly the negligence of violence. Now the question is, this is, let's say, the way how to persuade somebody with a threat of punishment. But I am going further. For example, in the calculation of all your costs, not only the near-term costs, but all your costs in a normal business cycle. If you could prove that investment in human rights, in respect for people, can finally increase the profitability of the company, despite the expenditures which are necessary, then probably you can make not only substantive changes in the work of the company, but also you can ensure some sustainability in this approach. Otherwise, if you only operate with law, look, if we say, yes, the state can impose on companies whatever the state wants, Okay? Theoretically, it works. But in fact, look at the other side of the coin. In this way, we are empowering the state. Interfere was, up to now, was, let's call it, private sector, private life. And if we empower this, it is certainly a sort of a confusing picture, because we, at the same time, we are afraid of state as a threat to our freedom, to our rights. At the same time, we look at the state as, in fact, the most effective guarantee of our freedom and our rights. Now, I would be afraid to empower the state too much, because in long term, it can again turn back, in fact, and create additional hazards to him. So we need to, what I want to say to conclude this a little bit perplexed picture, there is no one single way. There is no one single way to address this issue. We have to look at it in its entire complexity and try to develop various approaches. I like this presentation of yours, Elisa, because this was exactly a little bit playing on different pianos. But this is what we need. We cannot have a single performance. And I think in such a complex picture, what is also encouraging, that there is a role for all of us, as we are sitting here in the room, because everybody can contribute. This is a way how we can find our niche to contribute, how we can get involved, how we can develop our own determination to contribute. And I really believe that if we apply this multifaceted approach, we can be successful. And I think, coming back to your question, this is a very well justified question. And there are some, let's say, simple answers related to some specific tools, some specific bodies, and so on and so forth. But it is not everything. We need to look in a very complex way to it and try to find our own way in it. And the last point which I wanted to mention, I am a little bit concerned with this enormous emphasis placed exclusively on transnational corporations. And certainly everything what has been said about transnational corporations is right. They are really, they present at the moment the enormous challenge to everything what we understood as features of the modern society. That's fine. But it is not only transnational corporations. For example, if we in Poland today, when we will focus exclusively on transnational corporations, then in fact we are shifting the entire discussion to the relationship with the Trump administration. But it is not everything. We have our own companies in Poland. We have our own private sector in Poland. So we need to talk about corporate sector, and not only transnational corporations, although the transnational corporations, if we can say so, deserve special attention. Okay. Thank you.
I am aware we have already exploited the time allocated for the event, so I have a suggestion. If there are still some questions, I would suggest that you ask them directly after the event to the speakers. Mr. Pietrzak requested to excuse us, but he needed to come back to Warsaw. Elise, would you still like to say the final word before we conclude?
I'm going to say something I wanted before. And one of the reasons I accepted the invitation of Isabella is in part because I'm very curious. I had never been to Poland. I was happy to come meet you all and discuss with you. But I'm also so grateful as a human rights person for what you've done for Ukraine, for the generosity that your country has demonstrated to the Ukrainian people, and the inclusion of the Ukrainians, and the fact that you have fought a fascist government in place for 8 years and you succeeded in kicking them out. So to me, you're an extraordinary people, and I was very happy to come to Poland. So that's how I would like to close. It's not about the event, but I'm happy to answer any questions you might have.
Thank you so much once again. And if you have any questions, please approach after the event. I'm quite sure that our speakers will be happy to answer them. Thank you once again. And thank you to the speakers.